I'll put on Judith Colins in a minute, but in the memorandum, I had specifically said that Jacinda Ardern has placed unqualified ministers, most of whom are not born to New Zealand, and they are neglecting to pay due diligence to the oath to make effectual provisions to protect the nation of New Zealand, all right? And then I had asked, ultimately, down here, that we did pray for a letter to the Governor-General requesting an urgent temporary suspension of all changes to constitutional law, immigration policy and bills and acts by ministers that are not born to New Zealand nor allegiant to the oath that they swore. Now, I'm going to read this in its entirety soon, so you're not going to have to listen to it if you don't want to, or you can listen. But I am going to ask you to listen to Judith Colins, okay? And I'll come back. Now, what she's basically saying in here is exactly what is in my case. Is what I said is that these ministers, now Chris Farfoy was a media, geez, I hope I've got the right sound here. Chris Farfoy was a media, I don't really know what he did. He was the press officer or something down at the Parliament. And he, to my knowledge, he does not have any degree in law. He has absolutely no background of any law whatsoever. It basically comes down to that he was an unqualified minister. Now, New Zealand is currently backtracking all of their laws to 1991 because what they have been doing is allowing the ministers and the ministries to draft their own laws. And Lord only knows why, how our Governor-General is allowing these laws to pass into royal assent. They're going to royal assent after never even being looked at by a qualified lawyer. Now, the Human Rights Commission, to my knowledge, is drafting its own laws in the Human Rights Ministry, and then none of them have law degrees. Now, Chris Farfoy elevated himself from a media person, a person that was involved and not even a qualified journalist at that. He somehow elevated himself to be the Minister of Justice. And then there were other ministers, our Peter Williams CO, who was a priest, he was a bishop in a church, somehow managed to get him self-placed as the Minister of Courts. The Minister of Courts, who has no knowledge in law whatsoever, who was a bishop priest, who stood down probably about a year before he entered Parliament. He stood down from his position of being a priest, to my knowledge, the Mormon Church, or the Latter-day Saints as now it's called, and Chris Farfoy became a Minister of Justice. Now, both of them took those positions, and now it gets even worse. It's come to the light from Judith Colins that those ministers were drafting laws by themselves, passing it in 1, 2, 3 days, sending it up to royal assent, and the Governor-General herself was signing them off, and they were being passed into law. So let's listen to Judith Colins, what she has to say.
The problem is, and I'm sure that members, when they wish to read the report, will understand, is that if the legislation, secondary legislation is being...
So this is all being done under a thing called secondary legislation. What has happened now, this is over in England, this is over in Australia, we're all connected. What has happened is they were not able to get around the strict laws that the King handed Parliament. The Parliament was handed the ownership or the governorship or the sovereignty of Parliament was handed over by the King, right? But it was handed over under strict Parliament would be bound by the same laws that the King, the Prince and Princess of Orange were bound for. And so that was passed over to the Parliament. Now, what has happened is that Parliament have not been able to get around these laws to carry out all their dirty, rotten deeds. So what they did was they brought in this slippery secondary legislation where they thought that they could get around, and it's all gone pear-shaped. It's all just gone downhill. And so it's coming to the light through, you can thank Kate Floss for all this, to be honest. So there's obviously been an investigation over when I had called in the King. So Judith Colins is in fact a lawyer, and Winston Peters is in fact a lawyer. So they both have law degrees and they both know exactly what they're talking about. So she's come in to investigate this. So that's the secondary legislation that she's talking about.
And I'm sure that members, when they wish to read the report, will understand is that if the legislation, secondary legislation is being drafted by ministries themselves rather than Parliamentary Council Office, there is often not the expertise in the ministry to be able to draft clearly and within the rules that are expected of legal drafting. And that was really clear. It was also clear that things seemed to not get better but worse as matters went on. When I think to the criticism of the COVID-19 Response Vaccination Legislation Act, which was actually introduced on the 23rd of November 2021 and had its first, second and third readings on the same day, that bill received royal assent 2 days later on the 25th of November, and that was actually really almost 2 years after the full first brunt of the pandemic had hit us. That bill did not go to a select committee. It did not go to regulations review. It was not given the sort of scrutiny that people should expect. And I think it would be wrong to say that there was urgency. It was very unfortunate that this happened. When we look at the commonly known as the traffic light system that was introduced, it could have taken another week or 2 or 3, or even
So she just goes on to say that they could have taken some time and there was no reason. It was the end of COVID, but that's not really what the issue here. The COVID is just nothing now. What the issue here is that ministers who are unqualified in law, unqualified to their position, are drafting laws when it's supposed to go. They have an office, and I've just recently looked it up, called the Parliamentary Drafting Committee. And whenever a law, if the ministers are allowed to draft it themselves, and then they're supposed to send it to the Parliamentary Drafting Committee, and then they scrutinise every single inch of that act that has been done, and then they make it all legally correct so that it doesn't hurt people. And then part of my case was that they were psychologically waterboarding people with the law. Now, Judith Colins has come in and she has said exactly what my case was about. Now, I'm going to show you a clear example of this. Now, once the case got into the court, they then ask you, if they don't really quite understand what your case is about, you can put in a small case and then they will ask you for memorandums, and you can put in as many memorandums as you like. Now, the memorandums and then the opposition, so in the preliminaries, before it actually goes to the court, there are often exchanges of several memorandums, and you can add things into your memorandums that might not have been in the original case. The way that this happens is that you file your service papers, you send it to the ministers, and then the ministers will give you a response in the way of either they will completely rebut it to the court, or they will do it by way of a memorandum, and then you are permitted to feed off of that and then write your own memorandum, okay? And that's exactly how I ended up with all these memorandums. So if we listen to what Judith Colins said, now I'm just going to go ahead and read this. Now, some of you don't want to listen to all this stuff, so you can check out, and I will put up in the links, Judith Colins, but I will say to you that I have a lot of members who can't read, and so I like to read this for them. So this was the memorandum. They wanted me to put all of the laws, so I put all of the laws, every single law that I was going to be using in the court, I had put it in here in this memorandum, so it was clear that everybody could see what I was going to be using. So we had the New Zealand Bill of Rights Act, which England has got the English 1990 Bill of Rights. There's many rights, but none of them can hold a candle. None of them hold the ability to be able to serve papers on ministers and order them into the court. So these are all just supplements. And so what they've been using in this secondary law is acting as a pretended title of the Crown, that it's got the same powers when in fact it really, really does not. So I've used the New Zealand Bill of Rights Act, slash it out, Human Rights Act, slash it out. All these COVID laws came in through the ass end, through the asshole of these two laws here. The International Covenant of Civil and Political Rights and the Declaration of Indigenous Rights, Universal Declaration of Human Rights, the Human Rights Commission, and then the COVID-19 public health response. These are all tied up in here. And then S28 gives us, and unfortunately, for some reason, I did not put up there the 1688 Bill of, oh yes I have. Then under these all here come under laws, the top bits from New Zealand Bill of Rights down to COVID-19 are laws that they can change at will. And then it comes to our constitutional laws. S28 of the 1990s says all of our existing rights do not come under, not say don't come under, they are above all of these laws. I should have put this at the top. This is the Bill of Rights, 1688, Will and Mary. The Treaty of Waitangi, and I've not put up there the Declaratory Judgments Act, but I don't need to because it's up here in the original application. So that's not up there. These are just all the laws that I'm going to be talking about. But I came in on this plane. I call it the plane. This is the plane that I flew in on. And then you have to see where the plane's going to land, all right? So this is the plane that I flew in on. And it is in fact the only plane that you can fly in on. All these other ones you have to go to the lower courts. Now I said I am petitioning the court to intervene in the New Zealand Parliament for ruling arbitrarily against the people of New Zealand since 1986, when the 1852 Constitution was removed without referendum. The New Zealand public no longer have faith in the elections, as all parties have failed to hold any parliament accountable. And Judith Colins has just said it right there. Not only have all the parties failed to hold anybody accountable to the arbitrary laws, our own Governor General is assenting arbitrary laws. So it's a complete breakdown of what we had, nor defended the indubitable right of the people. Our own Governor General, who are they just picking off the street with no legal background, have been ascending these laws without any scrutiny, without any requirement that it goes to the the Parliamentary Law Drafting Committee, the Governor-General is just sailing them through on some kind of a plane. The New Zealand people are being forced to function under multiple legal systems, of which they are currently overwhelmed and distraught, such as hundreds of new subordinate laws in New Zealand, thousands of United Nations laws domestically, omnibus laws. I've done a video on omnibus laws, but anyway, it's just like dozens and dozens of laws all clumped together in one bill and passed in one day, and tribunal and so on. I don't really need to do this, but I said several petitions to remove our indubitable rights, which is our 1688 laws under the King, by our own parliamentarians and politicians who are not born. They're not even born to New Zealand, or they're first generation people to New Zealand, United Kingdom and Australia. They have no law degrees and they're not practiced in law, and they're drafting laws, and it's just being sailed on through by our Governor-Generals. It's shocking. The laws change daily at the flick of a pen, the epitome of arbitrary power, causing public inability to function in their daily lives. We do pray that for the court to assert by declaration an unquestionable and certainty of law of indubitable rights remains firm amongst the chaos of the broken New Zealand legal farce. You can apply this to the United Kingdom. We put in a special thing for our native chiefs, Tamati Wakanene, Witi Hikaru, and Wheat Parata, and other chiefs. These were the chiefs that signed up with all of our kings, and I've added them to the court. I've said amongst several other things, but we don't know it all. Each law must be a man unto itself, and they are ultra-vires. The government is overstepping its powers, especially when they're drafting their ministers who are not lawyers, who are not qualified to their position, are drafting laws and are sending it for royal assent without sending it to the legal drafting committee that is right next door to the Parliament, where they're supposed to send all of their laws. By using the Bill of Rights or the rights of they're using the Bill of Rights 1990 or the fundamental right as a piggybacked law onto our 1688. So they're getting our 1688, they're using this word Bill of Rights, they're not putting on it 1688, they're not putting on it 1990, so they only just put Bill of Rights, right? And then underneath that, they piggyback on all these dozens of laws using Bill of Rights 1990. And this is how they are arbitrary. It really is. It's a pretended title of the Crown. It clearly is. And they're sending it to the Governor-General, who is just signing it all off. There's nothing wrong with our legal system. Our legal system is fine. Our Parliament is fine. What is wrong is that they are not obeying the laws within the Parliament themselves, and Judith Colins has just announced it. Thank you, Judith Colins. The Ardern administration have a duty by oath to make effectual provision for the protection of our settlement. But Chris Farfoy is neglecting to control immigration responsibly, therefore endangering the New Zealand people by outpopulating them, contrary to the promise to the ancient chiefs. The New Zealand government deceived the New Zealand people into believing that the 1990 Bill of Rights is a constitutional law by lying by omission of the fact that it is an ordinary law and it can be overridden. It's just been ruled by the courts. It can be overridden at any time. All citizens of Commonwealth countries with Queen, I should have put Her Majesty, with Her Majesty the Queen as head of state are protected by the supremacy law. The combination of the 1990 Bill of Rights, the Health Act, the Human Rights Act, the International Covenant on Civil and Political Rights, the Indigenous Rights, the Universal Declarations, the Human Rights, the Declaration of Inconsistency, mass immigration with no controls, all contain laws that are inconsistent and repugnant to the 1688 Supreme Protections to the New Zealand people and the United Kingdom people and the Australian people and all the people in the Commonwealth. Jacinda Ardern, Chris Barfoy, Ashley Bloomfield, Chris Hipkins have not paid due diligence to their oath of office when administering the law. And they haven't, because when they were administering the law, they don't actually need to be that qualified. But since they are unqualified, what they're supposed to do, they've got a parliamentary drafting committee, they've got a whole building stacked full of lawyers that they're supposed to send their bills to, and those drafting committees will check all of this before it's passed into legislation as a safety check. It's supposed to go there before it ascends, and they have not been doing that, and that's called negligence, that's called not paying due diligence, and that, I don't know what the laws are, but they should not be doing that. So they should not, and they're all guilty. So the action of working towards a transfer, they were trying to make New Zealand, to bind New Zealand to any international instrument. We said that is ultra vires, meaning it's overstepping. This includes the WHO, all the United Nations. They said that they intend to make New Zealand bound to any international instrument. And so we've already got this in the court. So it's already there. So you can thank Kate Floss for that. We say that it is unconstitutional and treasonous to the oath of office to the Majesty and historical founding documents of New Zealand and the UK and Australia, including, never mind that's a bit to do with New Zealand. Jacinda Ardern has placed unqualified ministers, most of whom are not born to New Zealand, neglecting to pay due diligence to the oath to make effectual provisions to protect the nation of New Zealand, such as Chris Barfoy, who is not qualified, has not 1 ounce of legal background as Minister of Justice. He was made Minister of Justice. Now, Chris Barfoy is born in Tonga, all right? So why would you put a foreigner who came into New Zealand by either legally or not legally? I believe that his parents, I don't want to say, they may well have been legal or they may well have been not legal. But Chris Barfoy is birthed of two full-blooded Tongan parents. Two full-blooded Tongan parents. And they made him Minister of Immigration. Well, that's the fox in the hen house. William Seo is a full-blooded Samoan born, so in fact he is a Mātai chief, almost a king over in Samoa, and he was a bishop in the church, and he was made the Associate Minister of Justice and the Minister of Courts. So we had 2 foreign nationals who had not 1 iota of knowledge in law, in legal drafting, and they were both, according to, well, they may not have been, but I only know of the COVID health response, is that ministers in their ministries were drafting laws, passing laws, without sending them to the Parliamentary Drafting Committee, and then they were sending them to the Governor-General and then enforcing those laws on the people of our countries. Now, this is, I believe, what's been going on over in Scotland with your Muslim leader who is supposed to be Protestant, over in England with your Hindu leader who is supposed to be Protestant. And it may be happening, but I'm just speaking for New Zealand. So the Ardern Parliament has allowed these people are unqualified to their position. What does this mean? I'm not saying that they signed any laws or they didn't sign any laws. What I'm saying is that any law that they did sign that never went, and now I don't care if it went for amendments, they were drafting the law, they were enforcing it on the public, and then once the public started complaining, at that time they were sending it, to my understanding, over to the Parliamentary Drafting Committee, who were then amending it and removing all the laws that were repugnant. And this is just, it's unacceptable. Unacceptable. The video's getting a bit long, but my videos are. So any law that they signed to, that was ascended previous to it going to the drafting committee, all those laws are absolutely null and void, in my opinion, and I'm not even a lawyer, but in my opinion, they're null and void. Now, I'm going to show you something in a minute. The Ardern government has placed a disproportionate number of foreign people with no ancestral ties to New Zealand, nor allegiance to New Zealand, that work only in favour of their own people and have ignored the will, which is the 1688 Bill of Rights of the New Zealand nationals, all ignoring the subject status of New Zealand nationals and ignoring their oath of office. They are swearing their oath of office in other languages. They're not even swearing the oath in their own language, so we don't even know what they're saying. They are refusing to oath to the Queen. They are refusing to oath to the 1688. Is my video still on? Yes, I hope it is. And the Ardern Parliament has allowed several political parties to enter that are grossly repugnant to the oath of office under the majesty and duty to the people to uphold their protections of the supreme law. Ultimately, now I'm not going to read all of this, but we've said that. I will read it. Ultimately, we do pray for a declaration that all United Nations non-binding law, all human rights law, all declarations, all international laws are accountable and subordinate to New Zealand domestic law, with the Majesty as head of state, all Health Acts, all New Zealand ordinary laws, the New Zealand Bill of Rights, all pre-existing rights that have been attached, all acts of the Waitangi Tribunal are accountable. We're asking that they all be held accountable to the supreme law of the Bill of Rights 1688. Now that has actually happened. So that's come out in another act, which I've actually done before. I'll post it up for you. I have done a video on that, and that you can thank Kate Floss for that. That has already happened, and we've managed to get a law passed by an act, but unfortunately the act only says until 2025. So until 2025, there has been a proper enactment that has properly ascended, that has said that the supreme law of the 1688 Bill of Rights will overpower any other law, every single law. So we've got it placed up at top at least until 2025. So I don't know what they're going to do in 2025, but I will post up the link for that. You can thank Kate Floss and the Oreo team for that. Under the protection of the present Majesty, at this time, Her Majesty Queen Elizabeth was still alive. By divine intervention, Her Majesty passed midway through the court case, and we were able to ascend the King, who is sitting in the Supreme Court at this moment as we speak. and his successors already proclamated to His Majesty. She had already proclamated to His Royal Highness Prince Charles and future Queen Camilla, and we have said in all attempts to remove or supersede the supreme law under God are illegal and void. We do pray for a letter to the Governor General requesting an urgent temporary suspension of all changes to constitutional law, all immigration policy and bills and acts by ministers that are not born to New Zealand nor allegiant to the oath that they swore. The New Zealand public pray for some time to scrutinise. So we've only asked for a suspension for a period of time, and that has already been ordered in the first 100 days of Parliament as we speak. The New Zealand public pray for some time to scrutinise through the courts an investigation into the actions of many foreign nationals in New Zealand Parliament that seem to be functioning against the best interests of the New Zealand public and against the constitutional agreements set by the ancient Aboriginals, and this was set by the ancient Irish and the ancient Scottish and the ancient English people, but this is of New Zealand, and Her Majesty Victoria, Queen of the United Kingdom of Great Britain and Ireland, on the 14th day of January 1840 and the 26th day of September 1865, also including an investigation into New Zealand National's function pursuant to the consistency of safety and welfare of this Protestant kingdom, and the premises that all ministers' officers are bound to draft. Oh my gosh, and she's talking about all the ministers are bound to draft laws according to the oath, and supremacy in their office is required by law. Strict scrutiny must be conducted to affirm that all ministers and officers are deemed to be functioning within the boundaries preserved to the people by William and Mary and their successors. Thank you, Judith Colins. I think I'm just going to go back and listen to what she says. So she's talking about the drafting of laws, and it's just clear that they have been reading Kate Floss since the very beginning. So have a listen.